See, Mr. Blom is here. Mr. Blumberg, I believe you're on this file. Is that correct?
I am, but based on the court's earlier findings, I may or may not be. But I'm here today on behalf of Katherine Blom, the ex-wife.
All right, thank you. I appreciate that. I do see Mr. Brown here, who we appointed as the guardian ad litem. And Ms. Dottis Schultz is here, I believe. Yes.
Yes. Hi. Good afternoon, Your Honor. Attorney Jessica Dottis Schultz appearing on behalf of the petitioner in this matter for this case.
Right. I do see Betsy McKenna here as well. Who is with you, ma'am?
Christine Greider and Matthew Blum.
All right. Thank you very much. We were here in, I believe it was May, early May, and I entered an order after hearing on the objection to the appointment of conservator and guardianship. I did rule that Ms. Katherine Blom lacked standing, was not an interested party, and that the court orders or the temporary orders in both the guardian and conservatorship cases would remain in full force and effect. And then I asked Mr. Brown to be appointed. I appointed Mr. Brown as the GAL and asked him to inquire into some things regarding current and ongoing need for a guardian or conservator, as well as the issues of dissipation of assets, necessary medical care, placement, and the propriety of moving Mr. Blom out of state if necessary. Mr. Brown, tell me a little bit about your findings.
Your Honor, I did receive an APS report that I did review. I've also gone over the orders. Give me just one moment here. The physician's report in the initial filing, and there appeared to be an affidavit from Brianne Dalzell, who I believe was a nurse practitioner at Munson Healthcare, which first I want to make sure everybody has that.
The court does.
Yes.
Okay. I did have probably, let's see, back on the 30th, I met with Mr. Blom via Zoom. He is at the Meadow Lodge in Grand Traverse County. Speaking with him, first of all, he does not want to be there. He is unaware of any reason that he should be there. He doesn't know, you know, what is wrong with him. He wants to just go home. He feels perfectly capable to go home. I spoke with him about various life things. He went over things with Katherine, things with Matthew. He was a little confused, I think, with Katherine, whether he was still married or not, but then continually talked about getting remarried. He currently believes that Matthew has a restraining order against him, feels fully capable to take care of himself. There is some indication here, especially in the affidavit, that there may have been some influence here by Katherine, that Mr. Blom initially did not really object to Matthew becoming his guardian or conservator and even moving at that time. And this was just a couple of months ago, maybe 6 weeks ago. Based upon my conversation with him, the review of all my reports, especially, you know, it was reported that Katherine was his caregiver, yet there were some serious health issues going on with him. Given all of that information, it's first my opinion that he definitely is in need of a guardian and conservator. I believe that he thought Katherine was paying all the bills. The house is about to be foreclosed on because the bills hadn't been paid in probably over a year. So I understand his position, but given his diagnoses and my conversations and the reviews of the files that I've done, he is in definite need of a guardian and conservator. As far as him, and I would recommend Matthew at this point. I know he went from wanting Matthew to hating him. And I believe there's some influence going on there, is my understanding when talking to Meadow Lodge staff. that Katherine had to be asked to leave on multiple occasions, perhaps trying to insert herself into this proceeding here. So for all of those reasons, Your Honor, I would not oppose him moving if that is deemed by the guardian to be in his best interest. And with regard to any dissipation of assets, I've not seen any physical documentation. I will let the attorneys address that, but there does appear to be at least some indication that there could be, and things are being spent which are not paid for his home or his care.
All right. Mr. Brown, thank you very much for your investigation and your report. I appreciate the quickness with which you did that and the thoroughness that you took to do that. I appreciate it. Ms. Dottis Schultz, where do you want to go from here?
Thank you, Your Honor. Larry, thank you for covering the initial first 2/3 of my summary this morning, but I appreciate that. So to pick up, since we covered the APS report, the physician's report, and the current state of the temporary orders, we, at the last hearing, as you noted, Your Honor, you amended the orders and clarified that Fifth Third was to, in fact, release the financials pursuant to those orders, as well as we could issue subpoenas for financials to Katherine Blom and Elliot Blumberg for the attorney's fees and withdrawals and any monies that may have been spent from Edgar's accounts or dissipated from his assets while he has been, unable to manage his own financial affairs and going through the dementia. We obtained, Fifth Third did actually provide those records. I am still in the process of review due to the length, and we haven't been able to fully redact everything, which is why they haven't been circulated. However, that record will show that there was in fact a withdrawal, multiple expenses and withdrawals posted after the parties were divorced on February the 6th when it was entered in the family court, including on April 16th, the day that the temporary orders were granted. And that was when she went into Fifth Third Bank and had a cashier's check issued in her own name for $4,200. And Matthew had seen this check when he went to the house with the police after the orders had been granted. And we had been looking to verify this withdrawal. The other items, I haven't been able to reconcile everything, but that one does show that at least that $4,200 was taken out. With regards to, so I would ask for additional time to continue the review and for us to complete the accounting of the financials. 1 month would be sufficient. In addition to that, we did subpoena the records of Katherine and through Mr. Blumberg's office. And we were told that there were no records and that the subpoena was improper and needed to go through the family court, specifically as to attorney's fees and monies that might have been paid as we looked through all of the depletion of assets during this time. That was denied, and we were told that there were no financials that were ever provided. So we are left kind of trying to determine, what amounts, if any, were spent from the marital estate of Edgar's for this matter. Additionally, we had asked for Katherine to return items that had been taken from Edgar's car, including the items that were in the glove box, the car registration, the owner's manual, and those items, because they're going to seek to sell that vehicle. There's also a tote, like a clear plastic tote, like a rubber tote with a green lid that was seen full of documentation and records there. That was no longer at the house upon return by Matthew in this case. And we assume that Katherine had removed it, but nothing has been provided. Additionally, we had asked for, updates or information regarding an estate sale or the sale of the personal assets in the home, because there's nothing remaining except for a few odds and ends in the home. And Katherine had held a sale there previously and had been living there. Again, nothing provided and no confirmation of the same, denial of all information there. We would ask the court to, compel Mr. Blumberg's office to provide the financials in this case. And again, reiterate to Katherine Blom and Mr. Blumberg for his client that the return of these, personal items happen expeditiously, because there's no reason for them to be withheld. We did record with the County Register of Deeds the divorce judgment, and are in the process of having her expelled from the home. Additionally, there is evidence, that obviously we're not seeking to set aside the divorce, but that it was fraudulent, recognizing that's an issue for the family court. It's apparent, that Katherine Blom is not a credible individual, given that in the judgment of divorce on the second page, she actually claimed to still own her property in Florida. And at the time of the divorce execution and signing February 6th, stated that that was in fact the case. But we have records from the Pinellas County Register of Deeds showing that she in fact had either sold or gifted that property for $100 in November of 24 to her son. So she didn't own the property anymore at the time of conveyance. In addition to the fact that she had entered into Munson Hospital prior to Mr. Blum's transfer to Metalodge, and again at Metalodge, telling people that she was still married to Mr. Blum multiple times. So, obviously there's credibility issues there at certain times, so I don't think we can take anything. Her credibilities and character is highly at stake. So I don't think there's any merit to listening to any of what she's saying, or obviously we can't assume that she's telling the truth. So we would ask that the court grant the orders permanently for Matthew and his sister Christine as to the conservatorship. We would ask that for the conservatorship, add his sister Christine to the conservatorship with Matthew. She is already a co-guardian under the guardianship papers with Matthew. And given that the family is researching and needs to complete the Michigan Medicare paperwork first before they can transfer him to North Carolina, which will take a couple months. And in the meantime, they're looking to transfer him to Detroit. The granting of the conservatorship and would allow the family more manpower to handle the financials and coordinate care for Edgar, their father. Furthermore, we would want the return of all the personal property items from Katherine Blom and the extension of time to review the financials that we have been provided and return to this court with our updated accounting of the funds that have been depleted from this estate in 1 month's time.
All right, thank you. Mr. Blumberg, as to the request for the return of property and documents, your thoughts?
Well, Judge, I have listened respectfully and have not attempted to interrupt counsel in her absolute mischaracterization of the facts in this case. So where to begin? First of all, my divorce file was subpoenaed. We provided all the documents contained within the file, save for the conversations and emails exchanged between my client and myself. We have complied with that subpoena. The fact is that counsel and her clients have challenged the mental state of Mr. Blum at the time that the divorce was entered. That gives rise to the real question. If he was not, he didn't possess the requisite mental acuity and was unrepresented, albeit he signed the judgment of divorce, maybe in fact the divorce is not valid and should be set aside. That happens in the circuit court, the family court. And if that's the case, as they argue, then my client does have standing. She's still legally married to Edward Blum. Mr. Blum wants, as based on my understanding, to reunite with his ex-wife or his current wife, depending on the real legal status of the divorce. Mr. Brown met with him. I've had a conversation with Mr. Brown, and he shared with me the fact that Mr. Blum wants to go home and he wants to live out the rest of his life with my client. Both of these people are 80 years old. And I think the court needs to hear from Mr. Blum, and you alone determine his mental status. Because ultimately, he wants to return home. As far as his personal property that's alleged to have been stolen, monies in a joint account still are owned by these parties. They weren't awarded to one or the other. It's a joint account. So any money taken purportedly by my client out of the Fifth Third account, of which she is a co-owner, is not subject for this court's review. That's subject, if at all, by the family court. So what I would suggest, Judge, is that you keep the temporary guardianship and conservatorship in place until such time as we can have a full hearing on the issue of whether or not these parties are divorced. Because if they are not divorced, my client does have legal standing to challenge the placement of her husband. I think that would be the prudent thing for this court to do.
Thank you, Mr. Blumberg. All right, Mr. Blum, I see that you're here today. Is there any information that you want me to know about you, sir?
No, I don't understand why I'm being held still. It's just beyond comprehension for me.
How are you doing physically?
I'm fine.
Well, the information I got was that you had a broken back and we're having some difficulties with that. Is that still bothering you?
No. I broke my back probably about 1988. So that's been some time ago. Other than, typical senior aches and pains, I don't have any problems.
All right. I've also been informed that you weren't paying your bills at your house. What was going on with that?
Since I don't have control of my checkbook, that's hard to argue against.
Why don't you have charge of your checkbook?
Because I don't have it.
For the year that your house has not been paid for, did you have your checkbook then? Before you left your house, did you have your checkbook then?
Yes.
Why wasn't the house being paid for? Why wasn't the mortgage being paid?
I don't know.
Okay. I understand that you had a number of falls at your house before you were taken to the hospital. Why weren't you willing to let EMS come and provide some help for you so that you could get to the hospital and receive the care you needed?
I wasn't aware that that happened. I fell over a period of time, 3 times, I believe.
Yep.
And they're using that as a lever against me.
Well, EMS came out twice and you refused once, and then you went to the hospital this last time and they gave you quite a bit of care. Are you saying that you don't think that you needed that care?
I don't know what quite a bit of care consists of. They took me to the, in an ambulance to the ER. I might have been in a room for a day or two, and then they hauled me off there to Meadow Lodge without me having any input into that.
Did you believe that you didn't need any care at all medically?
Well, I'm not a physician, so it's
Well,
hard to
you know
quantify.
what you need care.
What?
I know, but you can know without being a doctor whether or not you need some medical help.
Well, medical help is kind of a broad spectrum of reasons. I have trouble with my legs. They don't always want to do what I want them to do. But that's no reason to keep me confined to this Meadow Lodge where I can't even go outside the building.
All right. Anything else that you want me to know, Mr. Blum?
Yeah, I understand that I never signed my divorce decree from Katherine. We were divorced approximately 2 days. And since then, the reason we were divorced was she was going to live in Florida and I was going to go to a care facility in North Carolina where my 2 daughters live. Since then, she has changed her mind about living in Florida, and there was no reason for us to be separated or divorced since we still both love each other. I don't know, the whole thing is like a Three Stooges drill as far as I'm concerned.
Are you telling me that you don't think that you signed the judgment of divorce?
That's correct.
I'm looking at right now in my hands a consent judgment of divorce that was filed with the court in February, and it has what appears to be the signature of Edgar Paul Bloom on the last page. Do you believe that you did not do that?
Since I can't see it, I can't agree or disagree with it.
But you don't remember doing that, is that correct?
That's correct.
All right. Anything else that you want me to know, sir?
No.
All right. Thank you very much. All right. The court does find from clear and convincing evidence that Mr. Blum is a person that is not able to care for himself and needs full guardianship because of his reduced mental capacity. He doesn't appear to remember signing the consent judgment of divorce, which appears from all other information that I have to have been signed back in February. It contains the signature of Mr. Blumberg, Ms. Blum, and Mr. Blum, and then the subsequent signature of Judge Hunter on page 7 of that document. I've also reviewed a report of a physician or mental health professional, Jonathan Bullock, a DO from Traverse City, who indicates that he believes that Mr. Blum is not able to make informed decisions about where to live, consenting to support services, handling his finances, and authorizing or refusing medical care, and that his prognosis is based on is guarded given his progressive decline, that he has a history of vascular dementia with behavioral disturbances, cardiomyopathy, was presented at the hospital with increasing confusion, refusing reasonable care, had I'm going to mispronounce this, but I believe it's pronounced rhabdomyolysis, which is a progressive injury from being basically bed sores or similar. Also had a myocardial injury, impaired mobility, and a vertebral compression fracture. And And then I've also heard from the guardian ad litem that was appointed, who also, in his learned opinion, believes that Mr. Blum is definitely in need of a guardian and a conservator. So for all of those reasons, I will sign orders indicating that Matthew Blum and Christine Greider will be the co-guardians and co-conservators of full-time. I will set a hearing. Actually, I will adjourn this out for approximately 30 days to allow the attorneys to do whatever they need to do involving any additional guardianship or conservatorship issues. I can't control the divorce court case. That's not my purview. So if there's anything to be done in that case, that would have to be done in the circuit court before the divorce judge. However, if there's any additional information that needs to be obtained, subpoenas or other normal discovery things will be allowed in this case. And we'll have a review hearing in approximately 30 days. I'm anticipating that if there's anything specific other than just a status review, that a motion would need to be filed by either party regarding that, so that the other side has the opportunity to defend, to have notice and to defend on that. So I'm not going to do anything other than the normal guardianship things at this time. Set a status conference for approximately 30 days to see where we're at. We'll do that via Zoom. And then any other issues can be raised via motion practice. Anything else, Ms. Dottis Schultz?
No, I believe that covers everything, Your Honor. Thank you.
All right, Mr. Blum, excuse me, Mr. Blumberg, anything else from your
No,
perspective?
Not at this time. Thank you.
All right. Does the family have anything else to add?
Thank you for your
Alright.
attention to this matter, Your Honor. Our goal is to care for our father, which I've communicated to him. We love him and want what's best for him. And we just thank everyone that's been involved in providing us the opportunity to care for him.
Thank
That's
you.
always good to hear, and I appreciate the sentiment. So keep doing a good job with that. All right, that's all for today then. Thank you all very much.
Thank you, Your Honor.
You.
I can do those letters of conservatorship to where it shows the co.
Yes.
Co-guardian. Yep, I'll just redo those and have them for you this afternoon.
Thank you.